Good afternoon.
Good afternoon, Madam Chair.
Thank you for visiting the Senate Finance Committee. Today is Wednesday, March 19th. We're going to hear a number of sponsor-only bills today, and then we'll have full hearings on 4 bills. So I'm going to start with, actually, if someone's not here, we'll just move to the next bill. Delegate Frank Conaway, are you here? Thank you, Delegate. House Bill 194.
Thank you and good afternoon, Chair and members of the committee. I'm Delegate Frank Conaway to introduce House Bill 194, Consumer Protection Retail Sales Payment or Reimbursement of Shipping Costs. And what this bill does, it says that a merchant must provide a prepaid shipping label or a refund for shipping costs to a consumer who receives an item that is damaged, faulty, or sent in error within 30 days of their complaint. And I'd be glad to answer any questions if I can.
Thank you. Sounds like a good bill, Delegate. Any questions for Delegate Conaway? No questions. Thank you very much.
Thank you so very much for hearing me today.
Next, we have Delegate Pam Gazzoni, House Bill 406.
Good afternoon, Madam Chair and members of the Finance Committee. For the record, I'm Delegate Pam Gazzoni, representing Howard County's District 13. I'm here to present House Bill 406 regarding the State Board of Examiners for audiologists, hearing aid dispensers, speech language pathologists, and music therapists. As introduced, the bill eliminated the role of all professional organizations from the board's appointment process to ensure consistency across organizations. In addition, the original language modified the requirement for what constitutes a quorum to eliminate the requirement that at least one representative from each discipline, audiology, hearing aid dispenser, speech language pathologist, and music therapist, was needed for a quorum. This quorum requirement frequently caused delays in addressing key issues, since if a representative from one of the disciplines is unable to attend, no meeting can be held. It was particularly challenging because the Hearing Society of Maryland, Washington, D.C., and Delaware, which is named in the statute as the organization that shall provide the hearing aid dispenser candidate list to the board and to the governor, is no longer in existence, making it impossible to nominate new hearing aid dispenser members. There is currently only one such member as a representative on the board. As amended, the bill simply removes the role of the Hearing Aid Society from the licensure board's process, ending the roadblock to appointing hearing aid dispensers. The bill passed the House unanimously, and I request a favorable report for House Bill 406.
Thank you, Delegate Gazzoni. Do I have any questions? Seeing no questions, that ends the hearing. Thank you very much. Next, we have House Bill 443, Delegate Denny Tavers. Thank you, Delegate.
Hello, thank you, Chair Vital, Vice Chair Hayes. We have a little doll. So I'm Delegate Denny Taveras, representing District 47B. And esteemed committee members, thank you for having me here. I'm here to request a favorable report on HB 443. Last year, we passed a monumental bill that mandates baby food companies to place a QR code on for-sale products that inform consumers of toxic heavy metal levels of arsenic, lead, mercury, and cadmium. This was the second bill in the country after California. This bill, HB 443, proposes a crucial update to the terminology used on these labels, changing toxic heavy metal to toxic element. This change is necessary to align with similar legislation California enacted. This harmonization of language will ensure consistency and clarity for consumers and clarity for customers, especially as products are being distributed across state lines. In closing, I ask this esteemed committee for your favorable report on HB 443. Thank you.
Thank you, Delegate. Do I have any questions on House Bill 443? No? I see no questions. Thank you, Delegate.
All right. Thank you very much. Have a great day.
So next we have House Bill 575 by request of the Attorney General, and that is, well, it says the Chair of ECM, but you don't look like Chair Wilson.
Good afternoon, Madam Chair, members of the committee. I'm Assistant Attorney General Howard Feldman, I submitted my written testimony in advance. I'm here to request a favorable report on House Bill 575, which will modify the Port Act, which was passed last year by the General Assembly. The bill seeks to reduce from 6 months from 1 month the reporting requirement for periodic reports to the General Assembly on the status of ongoing litigation so that we can provide more meaningful reports. The pace of the litigation, as you can imagine, is progressing but moving slowly. The trial of the first phase of the litigation against the Dolly and the manager of the vessel is scheduled for June of next year, and it's progressing through discovery right now. I'm happy to answer any questions. Otherwise, I'd like to request a favorable report on House Bill 575.
Thank you. We heard a very similar bill. It was not the cross file, but it was a very similar bill. Delegate Senator Mounts.
Thank you, Madam Chair. So with that litigation, so did we receive a settlement? Has the state of Maryland received funds from that litigation at this point?
Not from the litigation. There have been some insurance proceeds from the Department of Transportation. The Maryland Transportation Authority had an insurance policy, but there's been no settlement in the litigation itself against the owner or manager of the vessel.
And so when this becomes law, when will the reports be issued?
Every 6 months.
Every 6 months?
Yes, sir.
And where are you in the stage of the litigation? You're not even...
So the litigation is scheduled to proceed in 2 phases. The first phase, which is scheduled to be in trial for about a month in June of next year, relates to the vessel owners and the managers' request under maritime law that their liability be limited to the value of the vessel and the cargo under a federal maritime law. That litigation will proceed next year. It won't be until after that litigation is completed that the Judge Bredar in the U.S. District Court will issue a schedule for the second phase, which will be the trial of our claims and other claimants' claims against the vessel owner and the vessel manager.
Okay. Thank you.
Sure.
Thank you, Senator. Excuse me, I don't see any other questions. That ends the hearing on House Bill 575.
Thank you.
Excuse me. House Bill 722, Delegate Rosenberg, is he here? Okay, I don't see Delegate Rosenberg yet. I see Delegate Michelle Guyton, though, House Bill 745. Thank you, Delegate.
Thank you, Madam Chair. Colleagues on the Senate Finance Committee, for the record, I'm Delegate Michelle Guyton from District 42B in Baltimore County, and I am here to request your consideration of House Bill 745, which helps improve access to effective therapy for children with autism. And I know several of you have worked on bills addressing and trying to support our constituents with autism in the past, so I know you understand the importance of this. One of the most beneficial therapies for children with autism is applied behavioral analysis. However, many families are on our Maryland waiting list for services due to a severe shortage of qualified and licensed therapists. One of the reasons for this is something that we can actually address right here today, and that's that turnaround time for licensure in Maryland is much longer than our neighboring states. For instance, in Pennsylvania, it takes, I believe, 15 to 30 days to approve licenses. In Virginia, it takes 15 days. In Maryland, it takes 90 on average. So 3 times as long, if not much more, than in our neighboring states. And you all know that this directly impacts the time a child must wait to begin receiving these life-changing services, and that the sooner they can receive early intervention services, the more effective it's going to be. So House Bill 745 simply establishes a timeline for the issuance of licenses to practice behavior analysis to a qualified applicant. That means someone who already has their entire application in and complete to the board. I apologize for my voice today. The bill requires the State Board of Professional Counselors and Therapists to issue a license within 30 days of receiving the completed application, which puts us on par, generously, with states around us. And it requires the State Board to provide email notification regarding the status of an application for a license to practice ABA. The bill was unanimously passed out of the House, and I respectfully request a favorable report on House Bill 747.
Thank you, Delegate. I don't see any questions. Oh, I'm sorry, Senator Ellis.
Thank you, Madam Chair, and thank you, Delegate, for this bill. What's the reason for Maryland? I don't know if you have the answer. If you do, fine. For Maryland being so tardy, and well, I'll follow up with a question if you have that answer.
Sure. I don't know that I have a complete answer to that, nor do I want to specifically throw a board under the bus, so to say. But I will say that HGO has been working on trying to improve this particular board of licensure. And one of the obvious reasons that continues to come up is the fact that they do everything by mail. And that's one reason this bill requires them to actually give notification by email. You have to submit a check, an actual old-fashioned check, by mail to get a license. You have to put your application in by mail. They respond to you by mail, and so this is taking forever, and it's not quite, up to our standards in 2025.
Yeah, thank you.
So, yeah, thank you.
So in addition to requiring them to be speedier, it changes their internal processing, which will allow them to really be more efficient.
Absolutely. We're certainly hoping that it does.
Yeah, thank you.
Yes. All right. Thank you so much.
Thank you. I guess we assume that everybody has an email? I mean,
I don't have the answer to that. Certainly, if they didn't have an email, I suppose we could be flexible on that. But
okay. Just
generally, I
curious.
assume that most people would at this point if they're applying for licensure. Yeah.
Thank you. I think it should really speed it up. Do I have any other questions? I don't see any other questions, Delegate. Thank you. Oh, wait a minute, Delegate Jackson, Senator Jackson.
Thank you. Good to see you, Delegate. So that doesn't mean they can't stop using the mail system, right? They could do both, I guess. To the chair's question about, does everybody have email?
Thank you, Senator. You caught on that faster than I did. Thank you. Yes, certainly. If someone didn't have an email, they could still use the mail. We're not prohibiting that. We're just trying to help them speed up the process because we have a lot of people waiting both for the services and to be able to actually work with these families. So,
Thank you.
thank you.
Thank you, Madam Chair.
Thank you, Senator. There may be some other licensing processes we can look at to do something similar, so it's a great idea. Thank you, Delegate.
Thank you.
Is Delegate Spiegel here? House Bill 795. Thank you, Delegate.
Afternoon, Chair Beidel, members of the committee, good to see you all. For the record, Delegate Ryan Spiegel in support of House Bill 795. This bill helps public service employees in Maryland to get access to critical student loan relief through the Federal Public Service Loan Forgiveness Program by making 3 specific changes to the program in Maryland. First, it requires the Student Loan Ombudsman, which is a position that already exists in Maryland, to develop standardized materials about the program for public service employers in Maryland to provide to their employees on a yearly basis and at the start of employment. Second, it allows public service employers to annually certify their employees' status directly with the Department of Education, assuming we still continue to have a federal Department of Education, providing a much more streamlined way to certify eligibility, and it requires employers to proactively provide certification forms for employees who have requested them before. And then finally, it clarifies time requirements for considering when an adjunct or a non-tenured professor at a public college or university is eligible for the loan forgiveness program. Now, as I'm sure you know, student debt has grown out of control in recent years. The Student Borrower Protection Center reports that as of 2020, 5 years ago, an estimated 805,600 Marylanders owed $35.5 billion in student loans, with the average Marylander owing nearly $44,000. And again, that's 2020 data. So with the impacts of COVID and inflation and other economic challenges over the last 5 years, I'm sure that number is higher now. This financial pressure is worse for those employees who do the absolutely vital work in Maryland's public sector. Our teachers, our first responders, our healthcare providers, just to name a few, who face lower wages than their counterparts in the private sector, but still have that debt. HB 795 will not only improve the financial future of many of our residents, but also help us attract and retain quality state employees who may otherwise choose to pursue employment in the private sector. Congress created the Public Service Loan Forgiveness Program back in 2007, enabling public service employees to have their loans forgiven after 10 years of full-time employment in the public sector while they continue to make monthly payments on their loans. But when it came time for the first wave of applicants for loan forgiveness, they faced something like a 98% rejection rate because of procedural and bad industry practices. Numbers like those can drive employees hoping to use their skills for good away from the public sector. And federal loan forgiveness is one benefit the public sector provides that the private industries cannot. So it's imperative that we make as many positive changes as we can to incentivize public service workers to choose Maryland and stay with Maryland throughout their careers. And I know this is a sponsor-only hearing, Madam Chair, but I did want to acknowledge in the room a number of folks who testified in support of this bill on the House side, including representatives of the Cash Campaign who are here, Dr. Tisa Silver-Kennedy from the Maryland Center for Collegiate Financial Wellness, and Prince George's County Sheriff Carr, who all testified in the House in support of this bill because they understand its power to attract and retain good folks for these important jobs. And this effort is especially urgent now that we're seeing the impacts of mass layoffs on federal employees, some of whom, by the way, were very close to meeting the service requirements to have their student loans forgiven after years of public service, as detailed in a Washington Post article just this week, which I included in my written testimony to you. We need to make sure that employees receive timely information about this federal program so they can apply as soon as they are able, and we need to ensure that their applications are processed promptly by streamlining employer certification of their employment. Finally, let me just mention that the fiscal note also shows nothing more than a nominal administrative impact which can be absorbed with existing state and local resources, bearing in mind again that the cost of the actual loan forgiveness itself is borne entirely by the federal government. So thank you. I'm happy to answer any questions, and I ask for a favorable report on HB 795.
Thank you, Delegate. I'm looking, I don't see any questions. Thank you very much for your testimony.
Thank you all.
Yep, great bill. Next, we have House Bill 936, Delegate Emily Shetty.
Good afternoon, everyone. Chair Beidel, Vice Chair Hayes, esteemed members of the Finance Committee. For the record, my name is Emily Shetty. Thank you for the opportunity to provide testimony in support of House Bill 936, a bill that ensures health insurance policyholders receive proper notice when their health plans are canceled or not renewed. Under current law, individuals don't always receive adequate and timely notice, which leads to gaps in coverage that can have serious consequences for their health and financial stability. HB 936, as passed unanimously out of the House, requires insurers to send written and electronic notices of cancellation or non-renewal if an individual is opted in with their carrier, while also including information on alternative coverage options like the Maryland Health Exchange. This ensures that policyholders have resources that they need to make informed healthcare decisions within the special enrollment period when they actually can make those choices. Thank you so much for the committee's consideration of HB 936. This bill passed unanimously in the House with no opposition, and I believe the entire HGO committee signed on as co-sponsors. I respectfully request a favorable report. Thank you.
Thank you, Delegate. Senator Motz? I'm going to call you delegate before the day's over. I
That's
can-
okay. Hey,
We miss you. Come back.
in my
No?
world,
I'm not giving him up.
Oh, man. Okay.
But no,
That's fine then.
that's what happens when you ask a bunch of questions, right? The more questions. You started with Dunn, now it's Dell. I'll go all the way through. Real quickly, though, thank you for bringing the bill.
Yes.
And I was under the assumption that that was already the law. What?
You know, this is a great question. So under the current law, insurers have to send a notification of cancellation of coverage within a specific period of time, but by mail. And what this bill does is it adds email, and instead of only instructing folks to share about COBRA as an option, it also directs individuals to alternate options like the insurance exchange.
Yeah, so it adds that information, and then it
Yes.
also adds one other form of communication.
That's right,
information.
yeah.
I've experienced with this in the past. I think it was the mail went to the wrong mailbox.
Yeah.
And then the policy had been canceled. It was
Yeah.
health and home insurance, in multiple things, but in multiple instances. But thanks for bringing the bill.
Thank you, Senator.
Senator Guile?
Thank you, Madam Chair, and thank you, Delegate, for the bill. I did notice, I know you said there was no opposition, but in looking at the bill file, it does say that the League of Life and Health Insurers, their position was unfavorable. Did they change their position?
Yeah, so that was interestingly a mistake.
Oh, okay.
They actually sat with
Our
us.
good friend was
and-
here earlier, but I think he snuck out.
Yes, Mr. Salentano
Yeah.
Corrected the mistake during the HGO hearing. They had some brief suggestions that we incorporated by way of amendment, and those amendments were included in the House passed bill, which now has no opposition.
Okay, great. Thank you. Thank you very much.
Thank you for
Delegate.
allowing me to clarify that.
Yeah, thank you. Thank you, Madam Chair.
Thank you. I don't see any other questions. Thank you very much, Delegate.
Thank you, Senator. Thank you, Committee.
Delegate Dana Stein, House Bill 938.
Good afternoon, Madam Chair, Mr. Vice Chair, and committee members. House Bill 98 deals with the governing bodies of continuing care retirement communities, or their acronym is CCRCs. And a CCRC is a type of retirement community, excuse me, a type of retirement community where older residents can receive a continuum of care, starting out as maybe independent living, then going to assisted living, and then progressing potentially to nursing care. So current law says that if a CCRC has a governing body, then one of the residents or subscribers shall be a full and regular member of the governing body of the CCRC. The idea behind this is that CCRCs are the primary stakeholders of the CCRC. They contribute many times a large deposit, they pay monthly fees, and so they have a vested interest in making sure that, in the governance of the CCRC. So what this bill does, it says that if the governing body has a subscriber, then an alternate subscriber shall be appointed to the governing body. And the idea behind this is that at CCRCs, the residents tend to be older and sometimes not in the best of health. So if the appointed member cannot make it, then there's an alternate who can fill in for that person. And as amended, the effective date of the bill is January 1, 2026. And without amendment, both the providers and the Residents Association are in support of the bill. Be happy to take any questions.
You did a good job.
Thank you.
There are no questions. Oh, no, Senator Lamb put his light on.
Yeah, thank you, Madam Chair. Just a quick question for you. Obviously, I have CCRC in Vantage House in my district. Used to have one in Charlestown in Southwest Baltimore County, part of the district as well. And have heard from a lot of folks. So, support of the bill. Just a question about the Department of Aging only put a informational letter in. Any concerns that they have, or I'm just trying to skim this
I
really quickly.
don't believe so.
So they don't have any specific concerns. As amended, this should be fine.
Yeah, the providers, in the House hearing, the providers were favorable with this amendment, which we've taken, moving the effective date to the start of 2026.
All right, sounds good. Thank you.
Thank you, Senator. Now I don't see any other questions. Thank you very much. It's good to
Thank
see
you very
Delegate
much.
Stein. And now we have House Bill 979, Delegate Andre Johnson.
Good afternoon, Chair, Vice Chair, members of the committee. For the record, Delegate Andre Johnson, here in support of HB 979. Now, members, I'd just like to tell you that 979 and Senate Bill 844 were supposed to be cross-filed. However, they weren't cross-filed. Both were voted out unanimously on the House side and on the Senate side. This bill has support from the Consumer Protection Division of the Attorney General's Office, and 979, House Bill 979 is in the exact same posture as Senate Bill 844, so I respectfully request a favorable report.
Thank you for explaining that. I was asking our analyst, isn't this a cross-file? It wasn't, so thank you. I don't see any questions, Delegate. Thank you for being here.
Thank you.
And now we're going to go back to House Bill 722. I see Delegate Rosenberg came in.
Thank you, Madam Chair and members of the Finance Committee. Apologize for not being here. I was at the Speakers Society, and there was one person there whom I had not served with. Robin Ficker.
Oh.
Everyone else in my 43 years had been here. This bill is prompted by, over those 43 years, I've sometimes been accused of reading a newspaper story and then putting a bill in. Well, in this instance, that is true. The Banner and the New York Times did a story about the deplorable conditions at a facility where people were hopefully getting treatment for substance abuse. And in fact, their condition was getting worse because of the poor conditions. So what this bill would do is mandate two studies, one December 1 of this year, the other December 1 of next year, by our health department regarding such facilities where people are being treated for the opioid epidemic, and then report to us, the relevant committees, on their findings and as to whether the regs pertaining to such care needed to be revised for a long-term benefit and response to this particular issue. This is one of several bills coming over dealing with the opioid epidemic and how we are responding as a state. And this is a very visible example of how initially we have not responded appropriately, but feeling that these two annual reports and a explicit review of the appropriate regulations will have the needed beneficial effect. The bill passed the House unanimously, and I would urge a favorable report from the committee. Thank you.
Thank you, Delegate. And I also saw that article and was very concerned. I'm having issues with trying to see the bill online. Will the oversight continue, or is it just two reports and then it's over?
Well, as the bill sits now, it's just two reports, but it's certainly, I would think we would look favorably in the House if you wanted to expand it beyond those 2 years.
That really was terrible circumstances in that particular facility. Senator Lamb has a question.
Yeah, thank you, Madam Chair. Obviously, same thing, read the articles, just horrific circumstances that we were hearing about. We had actually taken the opportunity to ask the Secretary when she'd come up before the Joint Audits Committee previously about these types of circumstances and why this was allowed to continue as long as it did, even though it seemed like the department had some awareness that some of this was going on, but had not taken steps to really shut down PHA healthcare, for example, and they were able to continue on. on. I think some of the answers that we received during joint audits wasn't entirely satisfying, but so my question for you now is, this obviously requests that the department kind of do that evaluation internally. Why do you think they're the best ones to kind of do that look back, given the circumstances that they were also involved in this and, at least from my perspective, didn't take as quite a timely action as they probably should have?
Well, hopefully they've learned their lesson and would do a more thorough review, because it's not often that we pass a statute mandating that they do such a review. I would add my experience on the Budget Committee says that nothing concentrates the mind like, at least for a department, like budget language that mandates that you do something in the interim. And this is the equivalent of that. And certainly if we find that it was not the kind of review that we think is appropriate or sufficient, the law, if it passes, could be amended next year to account for that.
Okay. All right. Thank you.
I don't see any other questions. Oh, yeah, I do. Senator Kramer.
Thank you, Madam Chair. And Senator Lamb just touched very much on a shared concern that I have with the fox guarding the chicken coop here. And I was just curious if there was any contemplation of a third party stepping in to do this rather than the Department of Health looking to critique themselves, because I just have suspicions that we may not get the bird's eye lowdown on what's happening, leaving it within the Department of Health. So, I mean, I appreciate it. I agree. The relevance is very important. I just was curious, my good friend Delegate Rosenberg, if maybe there had been any thought with regard to some entity other than the department doing this analysis of themselves.
Speaking for myself, what matters to me is making sure this doesn't happen again.
Agreed.
And so what is the best way to do that? And I would be open, and I don't see that, I would see that as a friendly amendment if it was this committee's position that, say, joint audit should do the review. It would be from a different perspective than from the health department, I think. That's something to take into account.
All right, maybe we'll just have a conversation about what other alternatives there may be, not looking to do any harm at all to the bill in its current posture. But yeah, I'm just saying I share similar concerns to what Senator Lamb had to say. So thank you for the bill, and thank you, Madam Chair.
Thank you, Senator. We certainly don't want to kill the bill. It's too important. Vice Chair?
Yeah, thank you, Madam Chair, and thank you, Delegate Rosenberg, for bringing this bill. It's a really important bill, and I look forward to supporting it. The one question, I know earlier this session we had a briefing in reference to some of these recovery residences. It appears this bill, the scope will only look at those that are regulated, right? Those recovery residences that are currently regulated. There's nothing in here where they would, because I know the department was considering making some recommendations or looking at those that are unregulated. And I wasn't sure if that was part of the scope in which they're looking at.
Not part of the bill as it sits before you.
Gosh, no, great bill.
Thank you.
Thank you again, Delegate.
Thank you.
That ends our sponsor-only hearings, and now we're going to go to full hearing, House Bill 208, Delegate Andrew Pruski. Andrew, Delegate Pruski, is there, you have one favorable with amendment. Would you like to bring him up, or you just want to do your own presentation?
Sure, he can come up.
Okay, Nick Manis.
He's a nice guy.
Favorable with amendment.
Debatable.
House Bill 208. It's number 11 on our list.
Thank you, Madam Chair. And Mr. Vice Chair and the committee, thank you for allowing me to come here today. I'm Delegate Andrew Prusky, and I'm here to introduce HB 208, Consumer Protection, False Advertising, Digital Goods. This bill prohibits a person from advertising or offering for sale a digital good using certain terminology or alongside an option for a limited term-limited rental unless specified affirmative acknowledgement are received from the purchaser and the seller provides the purchaser with the required disclosure. Let me be clear, though, what this bill doesn't do, and I think this is important because there were a lot of people that submitted testimony and had questions. This bill does not require a person to download a digital good, does not prohibit a person from storing a digital good on a server that can be accessed through the internet. Additionally, the bill's requirements do not apply to a person who advertises or offers for sale a subscription-based service that provides access to a digital good or goods only for a duration of that subscription, access to a digital good with the requirement for monetary consideration, or a digital good for which the seller is unable to revoke the access after completion of the sale, including a digital good at the time of purchase, available for permanent offline download to an external source to be used without a connection to the internet. Now, I know that's a lot of words. Let me put this in plain language, what this bill does. We've had constituents and others who have come forward. For those of you that have kids, grandkids, or anybody that know, video games are moving to digital purchases. You actually don't buy a physical copy of a CD. You actually get a digital download. What's happening, though, is that there's a difference. You physically have something in hand versus something you're purchasing. And what's often happening is that license is removed after a certain time period. Why would that occur? Well, it could be the licensure had a limited time. It could be litigation that occurred, or it could be the company just went under. This has happened actually in several occasions for video games, and I've heard it through several constituents. And really, this bill is about acknowledgement and disclosure. California has passed a version of this law. The intent of HB is similar in that sense, that to define consumer acknowledgement and purchasing in plain language and the clarity that this legislation includes. Again, I want to reiterate disclosure and acknowledgement. Please note the fiscal note, as stated both on the state and those that are involved, is limited. I do want to acknowledge that we've had several conversations, even after the bill passed the House, that there were some questions on clarifying language, and also the Office of Attorney General had a few other cleanups. And we are certainly willing to work with anyone to make sure it works. I just believe that the principle of the bill should stay, though, about folks knowing what they're buying and what they have, and I'd appreciate a favorable report for HB 208. Thank you.
Thank you. Do I have any questions for the delegate at this time? Okay, let's hear from Mr. Manis, which I think you have a technical amendment for us.
Yes, ma'am. Thank you, Madam Chairman. Mr. Vice Chairman, who's coming back into the room, members of the committee, my name is Nick Manis, here today representing the Motion Picture Association and also Entertainment Software Association, in support with one amendment. The bill mirrors the legislation which passed recently in California, which the delegate just said, and what this one amendment would do would align us even further with California. On page 4, line 13, we are asking to replace the word person with seller. And you heard from Delegate Prusky that the seller is responsible for doing certain things before the person can buy the license for the digital good. And that whole section revolves around what that seller should do. But in the first, in the line 13, it says person. So we just want to clarify that the seller is the one that is responsible for making these acknowledgments and conditions that have to be met. For example, if a person responsible for advertising might have no way of knowing that the seller complied with the bill's provisions and could be penalized for that under the current bill as it's written. For those reasons, we ask for the amendment.
Thank you very much. Do I have any questions for Mr. Manis? I don't see any questions. Oh, Senator Guile.
I'm sorry, Madam Chair. Just really quickly for Delegate Prusky, what's your response to the requested amendment that Mr. Manis has asked for?
Yeah, I've seen the amendment. We're trying to work on the language, but I understand the intent. I know there's also additional language, but we will work with folks to get it across. So yes.
Okay, thank you. Thank you, Madam Chair.
Thank you.
So have you submitted those amendments to us yet?
I don't think so, or we just had. I know council should have gotten it, but you know, because of crossover and everything, we will make sure you get those and have
Just
them.
so council has it. That's
Exactly. Thank you.
Thank you. Thank you, Senator Ma.
just to make sure I understand the issue with the language, so the way it's written right now, the way this transaction occurs is that the person, the third party that's selling this subscription may not even know what the subscription is about. Is that the
No,
situation?
it's just the person is broad, so this would narrow it to the seller who's actually the one transferring the license to the individual.
Yeah, and who would be a seller? Can you give me an example of who the seller is?
Amazon, other companies that, retail outlets that might have the ability to sell it.
Yeah, and who would be the person, the entity that could be confused by this to be liable by the way it's drafted?
The one that produced the video game or made the video game.
Okay, all right. I just wanted to make sure I understood.
Thank you. Thank you, Senator. Now I don't see any other questions. Thank you very much. We do have two unfavorables, Sarah Price and Grayson Wiggins. Grayson, you can start.
Thank you, Madam Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. We're really more favorable with amendments on the bill. As Delegate Pruski noted, my understanding is California is the only state in the country with this law on the books. And so the two amendments we're looking at, the first is on page 4, line 16, changing at the time of the sale to before executing the sale. That would align with California law and help with checkout flow. And then on page 6, line 14, just fully removing the criminal penalties, which would also align us with California. I know the House removed the jail time provision, which we appreciate, but I think just fully removing the criminal aspect of this would align with some of the other changes that have been made on similar bills this year. Thank you, Madam Chair.
Thank you, Grayson. Sarah?
Good afternoon, Madam Chair and honorable committee members. Sarah Price on behalf of the Maryland Retailers Alliance. We are, I would say, neutral if amended. That not being an option, I did sign up unfavorable. We are requesting the same amendments as the chamber. We are also aligned with MPA's requested amendments. I did share the language with the sponsor ahead of the hearing. I do not know at this time what his perspective is on the request, but I did want to make sure that he saw the language before we all got here. So we would just ask respectfully that you align this language with the existing California law. Thank you.
Senator Reedy?
Thank you, Madam Chair. I guess for Sarah, was this language introduced in the House, or did you guys have this discussion in the House and it wasn't rejected, or?
We did share these requests with the sponsor on the House side, and they ended up not moving forward in committee. I cannot explain why right now.
Okay, no, I'm just curious. I mean, we want to try to get it right. I think it's a good issue, but maybe it just sounds like the sponsor might be open to tweaks, but we want to be careful, mindful of time too. So, okay, thank you.
Senator Jackson?
Thanks, Madam Chair. This may not have anything to do with the bill, but I keep hearing this is what California's doing. Why are we
Aligning
with California? I don't understand.
Generally, our perspective is that we have concerns about creating a patchwork of legislation when we're thinking about businesses that are operating in multiple states, especially when it's something like this that is dictating how a business is presenting information online. So an online marketplace is not necessarily going to be able to code their website differently for sales in California versus sales in Maryland. So that's why we are asking for alignment on something like this, so that businesses don't have to follow completely separate regimes or use different language. It's similar to the baby food law, actually.
Is it just that they passed the law first, I guess? Is that?
I mean, yes.
I'm just trying to understand.
So the precedent's already been set
Okay.
in a larger state with a larger economy, frankly. So we want to make sure that things are consistent for businesses that are operating in both places.
Okay. All right. Thank you.
Thank you, Senator. And Senator Kramer.
Madam Chair, just real fast, Grayson, you indicated that the amendment you all are seeking is that on page 4, line 16, that the words "at the time of sale" be changed to "prior to time of sale." Is that what I understood?
Before executing the sale.
Before executing the sale. Okay. And then the other was to just strike the misdemeanor criminal provision and retain a fine. Is
Yes,
that
sir.
correct? And Sarah, that you had
Yes, same.
the identical concerns? Okay. That's what I just wanted to check on. Thank you, Madam Chair.
Thank you. I don't see any other questions. Thank you for your testimony.
Thank you.
Just an explanation to the audience. When these are House bills that come over, if there is opposition, we do 2 proponents and 2 opponents. So that's why there's only a few people testifying on each bill. Next, we have House Bill 385, Delegate Mary Lehman. This is Consumer Protection Automatic Tip Prompt Screen Requirements. So Delegate, are you going to bring up Brian Markowitz with you?
Yes.
Okay.
Good afternoon, Madam Chair. I have the AG's office, Karen Strawn, and I
Karen
have
Strawn.
one virtual witness, I believe.
Okay, good.
Thank you.
Thank you. We'll wait to hear from all 3 of you before we ask questions. Okay?
Thank you, and good afternoon, Chair Beidel, Vice Chair Hayes, and esteemed members of the Senate Finance Committee. For the record, I'm Delegate Mary Lehman, and I'm here to ask your favorable consideration of House Bill 385, Automatic Tip Prompt Screen. This legislation was passed by the Economic Matters Committee both this year and last year. It was amended by ECM this year to disclose that the tip is for employees at a no-tipped option and require the Department of Labor and the Division of Consumer Protection to post information about this law on their respective websites. The 2024 bill was heard in this committee but not voted. Brief background on the bill. Prior to COVID, tips for food and beverage services were almost always associated with sit-down restaurants and were voluntarily added to a tip by the customer for prompt service and satisfaction. Now, coffee shops, delis, ice cream stores, countless other venues ask customers whether they want to add a tip for takeout food and beverages. This practice is known as point-of-sale tipping. It occurs when a cashier presents to the customer a tablet or another electronic device for the customer to pay for a purchase, and then the option to add a tip pops up on the screen. These screens do not specify to whom the tip is going, and sometimes the screen actually sets up a default tip amount that the customer must take action to decline. Both the Economic Matters Committee and the Finance Committee last year asked about the definition of the word tip and whether it is assumed to go to hourly workers or it must by law go to hourly workers. It turns out, and Ms. Strawn can speak to this, that in Maryland, the state actually has regulations stipulating that tips may only go to workers, not to management and not to owners. However, there is strong anecdotal evidence that online tips are not always added to workers' pay. Therefore, for 2 reasons, first of all, consumer right to know, and then secondly, for the protection of workers, this bill requires that a tip prompt screen must say some version of, and it's not spelled out in the language of the bill, some version of, would you like to add, would you like to tip the staff or would you like to tip the employees? And so note, some of the tip screen images that I did submit have a full sentence at the top. So in other words, they don't just have tip and then show the numerical amounts or no tip. And 2 of those images, if you have those, are actually from local businesses. One is the eatery in the State House, and the second one is a coffee shop on Main Street. And I will just say that coffee shop is not Starbucks. And the one actually has a sentence saying, would you like to add a tip? And the reason why I call this to your attention is that there is an argument by the restaurant lobby that changing the message could be too complicated for software vendors. That is completely unfounded. As you can see, there are all different variations of that question, from very simple, with the option for the different 15, 18, 20% to an actual sentence saying, would you like to add a tip? The legislation includes last year's amendment from the Economic Matters Committee that preserves the ability of workers who believe they have not been receiving tips entered through prompt screens to file a complaint with the Department of Labor. It ensures transparency for consumers about whom they are tipping and that they actually have a choice as to whether to tip and how much. It would still be left to the retailer. I want to emphasize that for any of you who are business owners. I know some of you are. It's totally up to the retailer still what tip levels to recommend on the screen, whether it starts at 10 or 15%, goes up to 20, 25, or other. A little bit about other amendments. I worked very diligently with the Maryland Restaurant Association through the interim to accommodate its concerns, and I supported a couple of the amendments, including one that specifies that the tip screen change does not apply to table service or to take out food either ordered on site or online but picked up in person by the customer. I also supported its ask that requires the Department of Labor and the Consumer Protection Division to put the requirements of this law on their respective websites. Finally, Madam Chair, I want to call your attention to a request by the AFL-CIO. They submitted written testimony favorable with amendment to adopt a labor language, a very simple provision saying that in a retail establishment where there is a labor agreement, that has to be honored. And then finally, there is an amendment that was made by ECM involving the maximum financial penalties for failure to disclose. That is an issue the AG's office will speak to. I did not support making that change, doing away with that language altogether. And I thank you for your consideration of this bill. I believe it's a pro-consumer and a pro-worker piece of legislation, and I am asking for a favorable report. Thank you.
Thank you. And now we'll hear from Karen Strawn. Thank you, Karen.
Thank you, Madam Chair. Mr. Vice Chair, members of the committee, my name is Karen Strawn. I'm with the Office of the Consumer Protection Division in the Office of Attorney General. We are in support of this bill, except for one amendment that we're going to recommend, but because it's mainly a transparency bill. When you go into a restaurant, you think, in most cases, when someone says a tip, most people think that a tip means it's going to the employees. And that's because by law, it should be going to the employees. Unfortunately, that's not always the case since the pandemic. It's being presented at lots of places that it normally wouldn't have been prior to the pandemic. And it's fine to ask for a tip. It's just something that needs to be transparent, that it's going to employees, and that you have an option not to tip if you choose not to tip. The part that we are asking to be amended is the provisions dealing with the enforcement of the law, which were added at the House. These are provisions that would take away the private right of action of consumers. This is something that is, in most cases, going to be a minor violation. It may take a lot of people being violated by that and having unfair and deceptive trade practices occurring by a business before our office would take an action. And so we think it's important that private consumers be able to take an action as well. And the other one is for a criminal matter. I think that's only going to be used in a situation that's very, very egregious, but we feel it's important not to take away enforcement penalties. So for these reasons, we ask that a favorable report be given on this bill, and I'm happy to answer any questions when you're ready.
Thank you. We do have one virtual witness we're going to hear from, Brian Markovitz.
Thank you, Madam Chair. My name is Brian Markovitz, and I am a shareholder at the law firm Joseph Greenwald & Lake. We represent employees, employers, and consumers throughout the state of Maryland on various matters. I will try not to be, I'll be very brief and not be redundant to the prior testimony and what I have in the written testimony. We support this bill because we believe it clarifies to whom tips, which are wages, are owed, and it also lets consumers know when they tip where their money is going, which, as was stated, is transparency that we need. Therefore, we urge a favorable report of the bill, and I'm happy to answer any questions that any of the members may have. Thank you.
That was very brief, Brian. Thank you. Okay, now do I have questions for either Brian or Karen Strong from the AG's office or the delegate? Senator Mounts.
Thank you, Madam Chair. And for the sponsor, I just want to make sure I understand what is the issue that is being addressed? Is it that tips are not going to the employees, or that the notice on the receipt is not clear, or is it lack of enforcement? What is the issue?
It's, I think, primarily, thank you for the question, Senator, first of all. I think the first problem we're trying to address is the anecdotal evidence, and this is me asking, and a lot of people I know asking when they are confronted with or shown the tip prompt screen, who's getting these tips, and workers saying, not us, we don't know where they go. In some instances, it might even be that it's hard to imagine, but it could be true that that owners or managers, especially I would say primarily in small family-owned businesses, don't know that they cannot, that by law they should not and cannot keep part of that tip for overhead or wherever it's going. And then the third piece is the consumer right to know, because with the exception of if you have the images I sent, and the place I got this idea, where I got this idea actually was seeing for the first time on a Panera tip screen, and Panera is the only company I know that has this, and since Panera is corporate owned, it's not a franchise, you will see that message consistently, and it actually says on the screen, would you like to tip the bakery cafe staff? So it's clear, but I've also, on top of it, asked at different Paneras who gets these tips, and they consistently say the staff on that shift. So I'm trying to address all of those scenarios.
Yes, let me try to back up. And I just threw those at you because I was surmising the testimony. And I was asking if it was the workers not getting their money, the consumers not getting notice or enforcement. And your response was long, and it covered several different things, but I think I drew something else from your response. Your response also included it was the employee doesn't know where the money's going after the tip is rendered through electronic tipping, whether it be the Venmo or whatever, off the phone or through a credit card. So the knowledge, the employee knowing where the money's going is another consideration, right?
I'm going to try to answer the enforcement part of your question.
No, that wasn't my question.
Okay. So for employees who are saying they don't know where it goes.
To be specific, my question is one of the issues that you're trying to address is that the employees don't know where the money is going. Is that?
Yes, and if I might say, because they know that clearly it is not being added to their pay. When I say they don't know where, it's not getting added on top of their hourly pay. They do know that for sure. So when they say we don't know where it's going, they're saying it's not coming to us. We're not sure who gets it, but we don't get it.
Okay, that's helpful. So, and this might be a question for the Attorney General. Is it required by law that tips are included with hourly pay, or can they be paid separately?
I apologize. I don't know the answer to that. I can check that out and find out for you.
So the assertion is that the tips are not being included in hourly pay, but that, to the best of my knowledge, there's no requirement that hourly pay include tips. And I guess that would be something that I'd be interested to know.
There is a requirement that the tips go to the employees.
Correct.
Yes.
Correct, but there's no requirement that when the hourly pay check comes, that the tips are included as a course of business. To the best of my knowledge, there's a practice where tips are paid separately in different forms or fashions based off of whatever that employment arrangement that's established between the employer and the employee. So I guess my question would be, if it's not required that tips be included in that hourly paycheck, is that a problem? Or is that a legal problem?
I don't think it's a legal problem, because they could certainly be paid their tips separately from what you're saying. But not getting the tips at all is the concern that we have.
Absolutely.
And that's what we're trying to get
that is law right now, currently.
Yes.
Yeah.
Yes.
But so, I mean, that's a separate issue from what this, I see, well, and anyway, you've answered my questions, so.
Thank you, Senator. And just to point out, the bill does not get into adding it onto their regular paycheck. The point that Ms. Strawn just said is they're not getting it at all in any form.
Yeah, but that's one of my concerns, is that the issue of the bill is the employee doesn't know where the money's going. However, the testimony that you just gave is that that's not a problem. It's just the fact that the employee gets the money. There's a disconnect in the way these things are interrelated, at least from what I'm hearing right now.
Yeah, I'm not sure. I don't follow the disconnect, but I'm happy to talk to you.
Well, they're two separate issues, right? One is the employee receiving the tips that they've earned? And the other is, does the employee is there some legal requirement the employee knows exactly where that tip money is, or how that tip money is delivered?
The bill doesn't attempt to address the delivery piece. It's just the fact that they are not getting the tip money at all, whether that's as a separate paycheck, whether it's paid out, maybe even potentially in cash, like it is at some sit-down restaurants. It's that they do not seem to be receiving it, period.
Absolutely, yeah, absolutely. And then I guess that raises one additional question. Have there been prosecutions? Has the Attorney General prosecuted for withholding tips or not delivering tips? Do we have any statistics on?
Well, we do know that the FTC took an action, and my written testimony has that as a footnote. The FTC took an action because Amazon was not giving the full tips to their employees. In addition, there was a recent action taken by the New York Attorney General in which they were, again, not giving the full tips to their employees at DoorDash.
Well, how about like the cantina and the State House and the coffee shop down the street? That was the testimony of the examples given. What about those types of prosecutions?
I'm not aware of those prosecutions at this time, but these are prosecutions for not giving full amount of tips. And if you're taking in something and you're calling it a tip on a tip display screen and you're saying, put in a tip one, and then it's not going to the employees, it's really the same type of thing.
Would you happen to know how many employees have called the Attorney General's office to say that I didn't receive my tips, my employer's not giving my tips, they're stealing my tips? How many complaints that the office has received, say, on a yearly basis for the past couple of years? Because I know we've talked about this over the past couple of years. And how many of those were investigated and prosecuted?
Well, those would not be situations that would typically come to our office because we typically are not handling the worker relationship. We're typically handling the purchase of goods and services. So right now, while the Department of Labor might be aware of that, the Consumer Protection Division isn't always getting that information. This would help to ensure that we would get that information.
So the Consumer Protection Division is now involved in this?
Correct.
Explain that connection one more time.
It has to do with the purchase of goods and services. So if you are purchasing and you are being given a screen to add a tip, that is part of your purchase. So for the consumer, it's a problem to not be providing correct information to the consumer and not be allowing the consumer to be aware of where the tip is going.
But this is a labor issue between the employer and the employee, correct?
It's both a labor issue and a consumer issue.
Well, once a consumer gives the tip, the money's no longer a consumer issue, right?
Well, it remains a consumer issue because it's part of the purchase.
Isn't the tip a gift?
The tip is a gift.
And by law, once a gift is given, it can't be taken back.
I would agree with that. I'm not saying that you could take it back, but it still is something that our office could look into whether or not that consumer was given transparency in where those tips are going and what is happening to those tips.
Yeah, I guess I still have some questions about the consumer angle on this versus the employer-employee angle. But thank you for answering my questions.
Thank you.
Thank you, Senator. I don't see any other questions. That ends this panel. And we have Melvin Thompson from the Restaurant Association.
Thank you very much, Madam Chair, members of the committee. I'm Melvin Thompson. I represent the Restaurant Association of Maryland. And we signed up as opposed unless amended. And I want to stress that we have been working over the interim with the bill sponsor to address our concerns. As we promised this committee we would do last year, we said we would work with the bill sponsor. And we are very much appreciative of the fact that she accepted many of our amendments over in the House. Our remaining concern is regarding the penalties, because under the bill, a violation would be a penalty of up to $10,000 for a first violation and up to $25,000 for a subsequent violation. That's our concern, and we think that that's a very stiff penalty for something like a mere disclosure violation. And that is because under the bill, a business's failure to provide the required disclosure would be considered to be an unfair, abusive, or deceptive trade practice within the meaning of Title 13. And the business would be subject to these penalties despite the fact that they distributed the tips to the employees as the customers intended and as labor laws already require. So we're requesting that the Senate Finance Committee adopt an amendment to require a written violation notice to the business and then allow that business 90 days to comply before any penalties would kick in. We think that that would be very appropriate for a violation of this type. And I also want to mention that we do agree with the amendment that was adopted in the House to exclude sections 408 and 411 from the penalty provisions. Section 408 does deal with private right of action. We don't think a private right of action is at all appropriate for this type of violation, and for those reasons, we agree with the House excluding that. And I also want to mention, just for purposes of background for the committee, in 2018, the General Assembly increased the penalties under the Consumer Protection Act. And the reason they did that was to address some abuses and deceptive practices by the financial services and lending sectors. Those fines were increased from $1,000 to $10,000 and $25,000, like I said. But those fines being increased because of the problems with the financial sector never envisioned it also applying to this type of legislation for a mere POS screen disclosure. And we think for those reasons our requests for this amendment are appropriate. And just jumping ahead a little bit, if the Senate passes this bill with our amendments intact, we would hope that if the House doesn't recede, that the conference committee also retains our amendment. Thank you very much.
Thank you. We did receive your amendment.
Oh, great. Thank you so
very
much. And again, thank you to the bill sponsor for working very closely with us to address our concerns.
Thank you, Melvin. So that ends the bill hearing on House Bill 385. Now we have House Bill 468. I see Delegate Austin is here.
Thank you, Madam Chair. I have two experts to answer questions. Would it be okay if they joined me? I know they're not signed up.
Sure, to answer questions, that'd be fine, Del.
Thank you. I also have some documents that may be helpful to the committee. It's my testimony. I don't know if I should just send it around later or if you all would like to have it now. Oh, thank you so much.
Tammy's coming out to you. Yeah, there we go. Thank you. Thank you.
Absolutely. Well, good afternoon, members of the Senate Finance Committee, Madam Chair, Mr. Vice Chair. Thank you all so much for the opportunity to present House Bill 468, Petitions for Emergency Evaluations. This bill is being presented after extensive work with the high utilizers group with the Sheriff of Prince George's County, as well as a work group that took place in the House of Delegates last year. And the reason this bill is important and needed is because in the history of the Prince George's County Sheriff Department, we've only had 2 deaths in the line of duty. And those 2 deaths occurred while serving an emergency petition, a petition to take a sick resident to the hospital for an emergency psychiatric evaluation. It was on August the 29th of 2002, 2 officers responded to the 9300 block of, I believe it was Latham Street in Adelphi, Maryland. And while those officers were trying to get the respondent to go to the hospital, in a split second, he went into his bedroom, grabbed a gun, shot both officers, fatally killing them. There was no time to think for these officers, and their lives and their family lives have been forever changed. And what this bill will do is it will clarify the Health General article that it is okay for law enforcement officers to use necessary and proportional force when serving an emergency petition. Now, I understand that the mental health community may have some concerns about putting use of force in the Health General article. But if that clarity could save one life, we need it. When you hear from the opposition, they will tell you that it's not necessary because they can already use force. Well, if they agree that you can already use force, why not provide the officers with the clarity that they are asking for so that we can show that not only we support them, but that it is okay when serving a civil order that you can use force to take a person to the hospital. No officer wants to use force, but in order to protect their lives so that they can go home and see their families at night, as a state, we must provide this clarity. They are dealing with very sick individuals who are in need of assistance. They have had training from across the country in de-escalation. So they talk the respondents down to try and convince them to go to the hospital so that they can get the help that either their doctor or their family members have went to the court asking them to get. And when you're going to the court, you're petitioning the court saying that this person is either a threat to themselves or a threat to others or both. And so these officers are putting themselves in danger every time they go to serve one of these petitions. And if they decided, well, they don't want to come, so we're just going to leave, then we have a sick person out there not getting the help that they need because they didn't want to come. And that's why the force provision is necessary. Last year during the work group, the Public Defender's Office, we met with them and they said they wanted the same language that was in the law enforcement officer statute about necessary and proportional. We agreed, we took that amendment and we changed the bill from last year to reflect that. In addition, the mental health advocates wanted changes about the 30-day extension. And the reason we need the 30-day extension is because sometimes a person gets wind that an emergency petition is coming. And because they know it's coming, they abscond, they leave, they may go across state lines or county borders to avoid being picked up and taken to the hospital. But that doesn't mean that the behaviors have changed. So in discussion, we came up with compromise language that says that for good cause shown and the behavior still being presented, you can seek an extension of 5 days so that law enforcement can serve the person. And so when you have homeless people, it's not like you have an address that you can go to if they're homeless. You have to find the person. And sometimes doctors are requesting these because they are aware of situations happening. And so this is just to give the law enforcement community time to actually serve. But there's still the high burden of showing that the behaviors are still there and presenting. And the court can decide on a case-by-case basis whether or not to extend the motion or to deny it. So it's still up to a judge to make that determination. And finally, what this bill will do is it will provide much needed clarity when it comes to the expiration time and date of these orders. So in our domestic violence statute, when you have a protective order, the protective order has a clear date and time for which it expires. Our emergency petitions do not. It just says 5 days. So the officer and the respondent are left to calculate when is it 5 days from what date, from what time? And so by providing the clarity, we will know that on January 5th at 12:05 p.m., this order will expire. So if it's not served, it's of no further good or use. That is a consumer protection for everyone, the person being petitioned as well as our law enforcement officers. So I'm asking for your favorable report. I understand that there are going to be people who are just fundamentally opposed to emergency petitions, and I respect their view on that. But as long as we have this process whereby we can request people to be taken to the hospital for mental health treatment, we need to make sure that our law enforcement officers are safe and protected when they go to serve these petitions, and that there is no ambiguity and that there's no lack of clarity or certainty in our code when it comes to serving these civil petitions. They are not criminal petitions where it's clear that you can use force. They are civil, and they are only meant to take a person to the hospital. So with that, I am happy to answer questions. I have Sheriff Carr, who was a new recruit when the two officers were killed. Also, Deputy Wiseman, who led our high utilizers group, and they both participated in the work group here that had On Our Own Maryland, Disability Rights Maryland, the Public Defender's Office. All of the stakeholders met last year to discuss this bill after the bill hearing, and that is where the compromise language that you see before you came for. So thank you.
Thank you, Delegate. We're going to start with Senator Jackson.
Thank you, Madam Chair. Sheriff Carr, how are you? Good to see you. Can you speak more about the high utilizer work group that recommended this change to the EP process and give us an example of how it might be necessary?
Okay, I do want to also refer to our Deputy Chief Wiseman, who definitely was instrumental. Taking office, actually, we created a behavioral health unit, and that was because of the high amount of emergency petition orders that were coming from the courts. And unfortunately, once we were taking these individuals into custody and transporting them to the hospitals were overwhelmed, and they were actually unable to facilitate and hold them for long periods of time. So if you had a citizen that actually needed long-term care, they were getting released and they were going back home, and then families were going back to the courts and then going and petitioning the courts to issue another emergency petition. So we created our behavioral health unit and high utilizer meetings really to talk about those who have utilized our services within a certain amount of time. I give the example all the time is we had an individual in the beginning of once we started to look at our numbers, we encountered him within 3 months 25 times. So that means we went to his address 25 times to take him to a clinical technician or hospital so that he can get seen and get the medical treatment that he needs. And this is nothing but medical treatment. Our expertise is not dealing with, diagnosis. It is actually dealing with basically providing a secure way of transporting that individual who is a threat to themselves or others to the hospital. I do want to have our Deputy Chief Wiseman then answer your second part of your question in reference to the work group meeting that we actually talked about over on the House side, if you could.
Yes, sir. So our high utilizers meeting was a monthly meeting that we established at the Office of the Sheriff with our stakeholders. We had 2 district court judges. We had people from the Department of Health. We had Luminous Health, the directors from the different hospitals that are located in Prince George's County, and other stakeholders part of this meeting. So in our meetings, we would talk about the loopholes in the system, the ways that we could work together to get the folks resources. We would do a case study every meeting where I would present someone that we had either had emergency petitions for multiple times or a more serious case that we were concerned that they were going to hurt themselves or others and they weren't getting the services. So we'd present the case study. We would come together as a group, try to get them resources, whether it was through the hospital, through the courts, the different entities in our county to get them the help that we needed. So on these monthly meetings, on several different occasions, we would talk about the problems with the system. So like an example of how the extension would help is we had a family that their daughter was a service member. They told us that she was sexually assaulted because of the sexual assaults that happened to her in the military. She turned to drug use. She became homeless. There were all kinds of terrible things happening to her because of her tactics that she learned in the military. She was surviving on the streets, but she was endangering herself. Obviously, being active in dangerous activity, and these poor parents were out on the street day to day, looking for their daughter, trying to get her the assistance that she needed. And often the order would expire, so they would have to go back to the courthouse, go through the whole process, file another emergency petition, and they had the community on the sides. The restaurants would report when they would see her eating in the dumpsters or trespassing. So them filing a motion through the court for an extension is a little less work on them as a community member, as a family member, trying to get their family members the help that they need. For the stipulations on clarity for law enforcement officers, in that moment where you have to make a split decision, it can be hard. So just knowing that I have a piece of paper that backs me that I'm not trying to use excessive force, I'm not trying to use force, but if the de-escalation or whatever's happening in the time, I don't have to think, am I justified to do this? It saves seconds, it saves lives. An example of a different type of force is we had a order for a woman who the family hadn't seen the child, her child, in several weeks. So they went to the court because she was sending all kinds of threatening messages. Her messages didn't make any sense. So when we got the emergency petition order, we went to the house, we knocked on the door. The neighbors could hear them walking in the house. But how are we supposed to get into the apartment to get this child to safety of the family members if the mom's hiding him in a closet, not feeding him, there's no food in the house? So if we had that wording that we have the right to forcefully enter the door, not even to forcefully take the person into custody, but to go in and make sure that this child is safe, because a judge has said this is an emergency and you need to take this person into custody, that would be helpful to us.
And if I may, one more.
One more question, but not a long extended answer, please. You weren't even signed up as a witness, so.
I apologize.
If you can be brief, I'd appreciate it. Thank you. Go ahead.
Can you just explain what happened with the line of duty deaths, either?
I'll let the sheriff speak to that.
Yes, back in 2002, unfortunately, we had two of our deputy sheriffs actually serving their emergency petition. They encountered the young man in the basement, was able to try to talk and de-escalate the situation. Unfortunately, it escalated to where he ran away from them from the basement level, ran upstairs to his room. As he ran upstairs to his room, he closed the door. Deputies then tried to continue to de-escalate the situation, standing in front of the door, trying to talk him out. Parents had notified the deputies that no weapons were in the house. Unfortunately, a weapon was present in the house, and he shot through the door, striking Corporal Arnaud, now Sergeant Arnaud, several times. And as he exited the room, he then shot Deputy Magruder as she was in the hallway, and then he fled the scene. So that's how that situation occurred back in 2002.
Thank you, Madam Chair.
Thank you. I know Senator Lamb had to go to another committee for a hearing. If he gets back, we may have more questions, but he's out right now. So stay close until we finish the hearing, please. Thank you. So we have one virtual witness, and it's Evelyn Burton. She's favorable with amendment. Ms. Burton, you need to unmute. Hit your unmute.
Sorry about that. Good afternoon. I'm Evelyn Burton, Maryland Advocacy Chair for Schizophrenia and Psychosis Action Alliance. We acknowledge that peace officers require clarity in the law to be able to use force when necessary when executing an emergency petition. However, the language in the bill does not make clear that all of the provisions of Section 354, the public safety article, should apply to the execution of an emergency petition. Provisions for the use of force and also those regarding use of de-escalation procedures. For example, Section 354E of the public safety article states, quote, "A police officer shall, when time, circumstances, and safety allow, take steps to gain compliance and de-escalate conflict without using physical force." Section 624A3 of the bill states, quote, "A peace officer may use force in accordance with Section 354 of the Public Safety Article when executing a petition. Our amendment would replace that language with, quote, "A peace officer shall execute a petition in accordance with Section 354 of the Public Safety Article, including de-escalation and use of force provisions. The use of force greatly increases the risk of serious harm and even death to the evaluee and the officer. Therefore, to encourage the use of de-escalation techniques and full compliance with all the provisions of Section 354 of the Public Safety Article, we request a favorable report with our suggested amendment. Thank you.
Thank you very much. Do I have any questions for Ms. Burton? I don't see any questions. Thank you very much, Evelyn. All right, if you'll leave the table for a minute, please. We're going to bring up some unfavorables. Courtney Bergen, Michelle Lipshin, Dara Johnson, Crystal Williams, and Carol McCabe. Okay. Courtney, when you get settled, if you'll begin, and you have 2 minutes. You all each have 2 minutes. Thank you.
Good afternoon, Madam Chair, members of the committee. My name is Courtney Bergen. I'm an attorney and Equal Justice Works Fellow at Disability Rights Maryland. And I'm here in opposition to House Bill 468 because Marylanders deserve a health care response to mental health crises, not a law enforcement response. In fact, under the Americans with Disabilities Act, it's clear that people with disabilities are entitled to reasonable accommodations. And there's an ongoing lawsuit in Washington, D.C. that the ACLU's brought in terms that requires or argues that jurisdictions are required to provide reasonable accommodations to people with mental health disabilities who are experiencing mental health crisis, which might include non-law enforcement responses to mental health crisis. I want to express, I have a lot of concern about this bill, and this bill is personal to me. I've been emergency petitioned, and I have been in situations where I did not answer the door when I was emergency petitioned. In fact, one of those scenarios, I was at work. I was emergency petitioned, didn't know it. Still to this day, don't really know why. I was in a yoga class and didn't answer my phone, and apparently that worried some people. I believe their concerns were probably legitimate, but what that ended up in was a few days later, I was in a meeting. I worked at a well-known hospital at the time, and I didn't see my phone ringing because I was in a meeting, and had calls from the police, from my landlord, from my roommates, all sorts of people wondering where I was because the police were threatening to knock down my door. I was terrified. Event has traumatized me to this day, and I can't imagine if they actually had forcibly entered my home. During the House hearing, it was stated that law enforcement want to be able to execute emergency petitions by any means necessary. That could kill people with mental health disabilities. They account for, depending on the statistics, between 25 and 50% of law enforcement deaths. So we would urge you to oppose House Bill 468 because this could be lethal to people with mental health disabilities. Thank you.
Thank you, Courtney. Who'd like to go next? Thank you.
Thank you, Chair, Vice Chair, and committee members. I'm Michelle Lipshin with Honor Own of Maryland, and I'm here today urging an unfavorable report to House Bill 468. We are opposing this bill because it does not align with the intended purpose of an emergency petition, which is to keep an individual who is in crisis safe and provide timely care in the present moment. We're very concerned that the articulation of use of force in this statute tacitly endorses an expectation that force will regularly be part of the emergency petition process. This is unnecessary and dangerous. The Maryland Police Accountability Act of 2021 and subsequent Attorney General opinion extensively defines the permitted use of force by law enforcement. And if agencies are fielding questions about this from their officers, couldn't training be arranged without legislative action? Across our statewide network of more than 7,000 peers served, we have heard many stories of individuals who have experienced harmful and long-lasting consequences from police response to their mental health crisis. and research confirms the disparate treatment of people with disabilities and BIPOC communities, like in this one story shared with us. I was emergency petitioned at 19 years old because I refused to take medication that caused troubling side effects. I didn't scream, curse, and I wasn't disrespectful. I didn't threaten to do anything to myself or anyone else, but the police slammed me into the car door, handcuffed me as tight as possible, groped and laughed at me as I heard my mother sobbing and begging behind me. It will likely haunt me for the rest of my life. I've now become scared of the police, wary of my neighbors, and I isolate much more now. Marylanders who experience mental health crises deserve understanding, support, and high-quality health care. This bill contradicts the primary purpose of an emergency petition and creates significant risk for serious harm. We strongly urge an unfavorable report. Thank you.
Thank you. Dara, maybe?
Hello, thank you, Madam Chair, and members of the committee. My name is Dara Johnson, and I am the Interim Policy Counsel for the ACLU of Maryland, here to voice our opposition to HB 468. So as it stands, this bill will make a horrible problem even worse by subjecting our most vulnerable communities to an even greater risk of harm based on public data that we compiled of 143 people who died from police use of force from 2015 to 2023, 67 were definitely or possibly experiencing a behavioral health crisis, and at least 23 have publicly reported mental health diagnoses. That means deaths during mental health crises accounted for nearly half of these fatalities. These 143 deaths include 24 people who were unarmed and fleeing when killed, of whom 84.2% were people of color. This speaks to the heightened impact that misuse of force under this bill will have on our Black and brown communities. Despite comprising only 31.6% of the state population, Black Marylanders accounted for 64.3% of these 143 deaths. If anything, we should be focused on exercising special care when responding to mental health crises, not further authorizing officers to revert to violence to force compliance. This is especially true within the emergency evaluation process, as the ability to force related confinement is subject to hazy probable cause standards and can be compelled by potentially faulty judgments of a lay petitioner. We have heard from many people who were involuntarily committed by petitions compelled by a lay petitioner, who could have easily used this process as a means to push a personal issue rather than address a real safety concern. The application of the use of force and petition extensions under this bill clearly risk running afoul of protections against excessive force, stale evidence, and disability discrimination. With this in mind, we implore you all to reject the broader leeway this bill provides for violent responses to public health concerns and urge an unfavorable report. Thank you.
Thank you. Crystal Williams?
Thank you. If I may defer to my colleague Carol McCabe to go first. That's fine.
I couldn't hear you.
If I may defer to Ms. McCabe, the Chief of our division, to go first.
Okay,
Thank you.
Good afternoon. My name's Carol McCabe. I am the Chief of the Mental Health Division in the Public Defender's Office. The Mental Health Division represents approximately 800 to 1,000 individuals in involuntary civil commitment cases in private hospitals across the state every month. The vast majority of our clients were hospitalized pursuant to EPs, and the majority of the emergency petitions we see were issued by police officers, not the courts or mental health clinicians. Under Maryland law and constitutional law, an EP can only be issued if there's reason to believe that an individual has a mental illness, and derivative of the mental illness, the individual is presently dangerous. Police officers can execute an emergency petition on the spot as long as the police officer sees an individual and the individual meets the legal criteria. To comply with the Constitution, the information the police receive regarding dangerousness can't be stale. Last year, there were meetings between mental health advocacy organizations and Delegate Alston and others regarding the bill, and I did not attend those meetings, but I understand from people who were there, including people from the Public Defender's Office, that changes were discussed, and the bill has in fact been changed, but the Public Defender's Office and other groups indicated they would not be able to support the bill in spite of the changes.
and I'd like to just talk about changes with respect to the EP process. HB 468 allows extensions for 5-day intervals for a total of 30 days. The amended bill requires that the individual who filed the original petition return to the courthouse to make a motion to extend for good cause based on presenting behavior. Does that mean that the presenting behavior, it was the presenting behavior 10 days ago, 20 days ago, 25 days later? I mean, it's not clear in the statute whether or not stale information can be used. This bill is unnecessary because under current Maryland law, individuals can go into the courts as often as they want, and they can request an emergency petition, which is a one-page document. And so it's completely unnecessary to add this provision to the bill. And I'm happy to answer any questions that you have.
Thank you. And now Crystal.
Thank you, Madam Chair, and members of the committee. I'm here to offer, thank you. I'm here to offer additional testimony, raising our concerns with HB 468. And again, while we do want to certainly acknowledge that there have been previous meetings with our office and the House bill sponsor in efforts to narrow the application of the use of force, we still do remain concerned with codifying the use of force to be used against individuals experiencing mental health crises. Most importantly, we believe that it is in contradiction to the goals of moving Maryland towards best practices and providing mental health supports and less police involvement. We know that the current use of emergency petitions are used in a manner that can be abused and are being provided in cases where individuals do not actually meet the criteria for dangerousness. Anecdotally, we know from our mental health attorneys that they have been advised that approximately 50% of individuals emergency petitioned were released back into the community from the emergency room because they did not meet the criteria for being dangerous. That's a startling percentage of those being subjected to such an invasive process that in and of itself is dangerous to the individual and those involved. And so before codifying a bill that endangers the lives of individuals who may be experiencing mental health concerns, it is important to get real data and information regarding the use and abuses of how emergency petitions are being used. Most importantly, is the process effective in accomplishing the intended goal of making sure that individuals who are in need of immediate mental health services are getting those services to eliminate or mitigate any concerns or threats of harm? What we don't know is how many of these petitions are being denied or falsely filed. We need more data on who is filing these petitions, who are these petitions are being filed against, and how many of them are being provided with verifiable, substantiated evidence involving immediate threat of harm. How many of these petitions are being filed repeatedly, and what are the actual outcomes of these petitions? We know that there are far too many occurrences that involve individuals misusing or overusing the process in domestic violence cases, divorce cases, custody cases, and instances where family members are trying to control finances. And also in schools against children, which is a very important part that I wanted to highlight. Thank you, Madam.
Thank you. Do I have any questions for this panel? Senator.
Thank you, Madam Chair. I guess for the folks from the Office of the Public Defender, you had alluded to that there were some substantive changes to the bill. I understand you were part of there was a work group that occurred. No? Shaking your head, no.
There was a meeting like after the bill hearing.
Okay, yeah. I heard that there was there a work group?
There was a group, I may have referred to it as a work group, but last year after the bill in the House, there was a meeting with advocates and Delegate Alston regarding the bill. That was last year.
Okay.
The delegate had mentioned it in her testimony.
Okay. And then it's my understanding that there were some you alluded to some substantive changes to the bill that makes you now in the position of opposing it. Maybe you could, you started to explain some of those substantive changes. Can you help us understand what those changes were?
Sure. So there were a couple of substantive changes made as a result of that meeting. I was not part of the meeting, so I'm hearing about this secondhand, but Ms. Bergen was actually at the meeting. But the changes that were made had dealt with narrowing of the use of force. We were concerned that the use of force as described in the bill before it was amended actually allowed police to use more force against people with mental illness than they would be able to use against criminals. And we were concerned about the extension provision, because as I said, in order to be constitutional, you can't just drag someone off the street unless they're currently dangerous. And so there were some changes made that attempted to address that behavior, but the way the bill is drafted, it's not clear. It just says, they can return to the courthouse to make a motion to extend for good cause based on presenting behavior. And does that mean the original presenting behavior or the behavior 10, 20, 25 days later? It's not clear, which means judges could be granting these extensions based on stale information, which would make those extensions unconstitutional. So those were the changes made. And my understanding was that, while those changes were discussed, at the end of these meetings, the mental health advocates advised that even with the changes, they would not be able to support the bill. One of our major concerns is that the process that exists in Maryland violates the ADA. There are class action lawsuits in a number of states who have the same process we do. So in Maryland, if you call 911 for a medical emergency, you get a medical response. If you call 911 and say it's a psychiatric emergency, you get a law enforcement response. And so the Department of Justice actually filed a statement of interest in the class action lawsuit against Washington, D.C., which uses the same process we do. And the Department of Justice said that that process violates the ADA. So that was one of our continuing concerns, and we still believe that the process in Maryland violates the ADA.
Okay. And it's my understanding there's some discussion related to some study language. Is that right? I'm hearing that there was some discussion related to study language. You're all looking at each other as if there wasn't.
Which study?
I know last year we had talked about needing to study this issue before doing this, because there's no public data on emergency petitions. As we talked about, there's like 3 different groups that can EP people, and there's no data around what's happening, even like total numbers. There's been some journalists who've been reporting around what's been happening in schools, but beyond that, the only real data right now is in Baltimore City because of the Baltimore Police Department consent decree. And I'm actually part of that group, and it's one of the things that concerns me most about this bill is like they've been doing a significant amount of work to reduce the use of force in specifically behavioral health encounters. So I feel like this would actually kind of go against the work that department has been working really hard to do.
Did you or anybody, did you reach out to the opposition to do a study on the EP process? Did you communicate at all?
So we had proposed also, we said that we need public data on this, not a study specifically. And so fall last year, we discussed the data, but I can't remember if we provided any information, but we said that we still cannot support even with the data available. And this year we did provide some data points, but the data is too disparate right now. It's with the police department, it's with the hospitals, it is with community care providers, and there's going to need to be a lot of work done to collect or synthesize the information in any coherent way. However, this is a human right. This bill is about human rights. And so while we do need data, passing something without sufficient data or information is dangerous for Marylanders.
Okay. All right. Well, thank you very much. I appreciate it. Thank you, Madam Chair.
Thank you. And Senator Jackson?
Thank you, Madam Chair. I have a question. So let's say EP is issued by the court and it has to be served. So the officers go there to serve out the EP, and there's a situation that we heard before where the person had a gun and all this kind of stuff. How are they supposed to defend themselves, the officers?
So I think we've been saying is pretty clear is that if there is an incident where someone, has a gun, police can certainly use force then. And we're not trying to suggest that police should just stand back and let things happen. Absolutely not. We're just saying that if there's just because you can't see somebody who's like not coming out of their home, there's so many reasons that can happen. I mean, there's my situation where I wasn't home, but I've had situations where I was home and I didn't answer the door. And if the door had been knocked down, I hate to think about what could have happened. So we're saying, they shouldn't be able to presume that force should be used. These are supposed to be healthcare encounters. I would even go so far to say police shouldn't be involved in these encounters. Other states have other solutions and don't involve police in serving these. So I think that's what we're really trying to say is that, yes, if someone, answers the door and points a gun at the police or starts hitting them or some other violent action, of course police should be able to use force then. They just shouldn't be able to kind of default to using force in serving EPs.
But it sounds like to me that there's some, I don't know if the expectation is for them to not use force, and that's.
So the public safety code right now says that police officers are able to use necessary, reasonable, and proportional force. And so if there is a gun, if there is a significant threat of harm, police officers can use force. And so what we're speaking about is the emergency petition language is a health article. It is about a public health response. And so putting language about use of force in a public health response is unnecessary and has potentially dangerous implications when they're already being met with force in these encounters. So we're not proposing that police officers don't use force if there is a gun or there's a significant threat of harm. The statute already protects police officers.
But it was the testimony that this bill says by any means necessary. Is that what?
During the House hearing, that was what the proponents of the bill had said, that other times orders say they can be executed by any means necessary, and that sometimes EPs say that, and they really shouldn't say that.
But that's not what this bill says.
No, but it was stated by the proponents in the House hearing, and I'm happy to send you I have the link timestamped where that's stated.
Okay, but what does this bill say?
The bill says reasonable and necessary, and that is, or necessary and proportional, yeah. That is what can already happen. The difference is can you use that when you can't see somebody just to execute an order? And that should not be the case when you're talking about an emergency petition, just, to be able to take someone into your custody by force. Now, if someone is acting violently, that's very different, but I think it's around 70% of people who are having an emergency petition served on them are a danger to themselves. They're not a danger to others. So you're really putting them in danger of suicide by cop with something like this.
Thank you, Madam Chair.
Thank you, Senator. Senator Mao.
Thank you, Madam Chair. And this is a quick question for one witness. Every witness is going to respond to it. Now, I always mistake your name. I apologize. In the pink in a...
Courtney Bergen.
Courtney, I apologize if I got the wrong color for your jacket. But so I'm thinking about this, right? And I understand the law enforcement concern, and I also understand the respondent concern, And then in the meantime, I also have had so much experience with the new oversight over police and the accountability boards and all the things they go through. And I understand we've been too close to too many of these situations, But at the end of the day, I seem to think that, with all of the scrutiny that now shadows every action and everything the police do, that there's, and this is a question for you, Courtney, that there's a tremendous layer of security in knowing that, things are being done properly, that there's review and that sort of thing. And it tends me to support the bill. And I'm interested to know your response to my thoughts in analyzing the pros and cons and considerations of the bill.
I think you're right that we've made some progress on police accountability, but I think we need to be thinking about the specific population that we're talking about here. And as I said, I know a lot of people, think that people with mental illnesses are dangerous during a crisis, but that is a very small minority of people. Most of these people are probably in the most vulnerable state they've ever been in. So I think if we start to authorize explicit uses of force, and at times when other states are really working to try to eliminate the use of law enforcement in this process, I think Maryland is going in a direction that could be really harmful and put people with mental health disabilities in significant danger. I mean, as ACLU testified, they already account for about 50% of deaths. And I think doing something like this where it would be endorsing a use of force in the emergency petition process, it's sending Maryland in the wrong direction. And just as someone who has been emergency petitioned, it's a terrifying process. It doesn't matter, if police are using force or not. The fact that you have a cop, I'm someone who is terrified of law enforcement, quite frankly, has never been in trouble with the law, tries to do everything I can to follow the rules because I don't want to end up in these interactions. But you're in a crisis. You're supposed to be getting help. And when police show up, no matter how good those police officers are, I've had interactions where police have been great. But the fact is that they're showing up, they have guns, there's usually multiple of them, and there's one of me. And it's a situation where I'm outnumbered, I'm in a very vulnerable state, and I know that that's the vast majority of people in these situations. And so I recognize that there's, the opponent said there was 2 deaths, but during that time frame, there's been thousands. I have a friend whose husband was killed by police when he was served an emergency petition in the past 2 years. And it is devastating to me to think that, we would pass a bill like this knowing the vulnerabilities when, there's, people who are dying every day in these interactions.
Yeah, I guess, and have you, in considering this and thinking about it, and I'm going to get the acronym wrong, CIT or CTI training, and what that has done for law enforcement in dealing with these situations. Did I get that correct?
CIT, yeah, Crisis Intervention Team.
Yeah. Do you see value in that type of training and dealing with these situations?
I personally think it's a complicated issue. I think at the end of the day, you need to be thinking about what's the person who's being petitioned think. Even if those law enforcement officers have had CIT training, the people who are being petitioned don't necessarily know that. They don't know if these are going to be officers that are going to come in guns a-blazing or if they're going to be great. Like, it could be both, depending on a lot of different factors. And so while I think CIT training is certainly useful and certainly important, I don't think it solves a lot of the problems. And I think, one of the states I would really encourage people to look at is Washington, where they've started shifting this process to healthcare providers who are designated crisis responders. And I think if we could look at other solutions, law enforcement officers are law enforcement officers. They're not mental health providers. And I think we can try to make them more sensitive. And I think those trainings are important, but I don't think they really solve the underlying issues.
Well, thanks for taking my questions.
Thank you, Senator. And Senator Lamb made it back. He did a bill hearing in the House and came back, and it's still time for questions. Now, Senator, this is the unfavorable panel, but I asked the sponsor panel to stay. So who are your questions going to be directed to?
Could I start with the unfavorable? Or
you can start.
Since they're already up here. Okay. So I guess with regards to the use of force issue, I'm curious to see if there's been any court filing or AG's opinion to suggest that that we need to clarify the use of force when being applied against an emergency petition.
I'm not aware of any.
So none.
No.
I guess there are a lot of other orders that don't include the use of force language, things like peace orders or ERPOs, in most part because it seems like law enforcement would have to follow the use of force law that's already in effect. And so, I guess I question why, we need to have a use of force provision in this, given that, there's already in statute a use of force part of the statute that applies to emergency petitions, right? So your understanding is that would apply to emergency petitions in this instance?
Yes, that's correct. I mean, police officers can and do use force in the execution of these petitions every day. and they have been for as long as I've been with the Public Defender's Mental Health Division. That's since 2016.
And is it your understanding that healthcare providers already have the ability to emergency petition people in the event of an emergency mental health
Yeah,
need?
EPs can be issued by police officers on the spot. They can be issued by a number of various mental health clinicians who then give the EPs to the police for service, and they can be issued by the courts, who would also then give the EP to police officers for service.
And the EP process is ex parte, right? And so
Yes.
the judge never sees the respondent and is really just kind of going off the third-party reporting in that instance. So have you ever heard cases where the third-party nature of this process makes it, easy to abuse, so to speak?
We have many cases where this process has been abused on multiple occasions. In many cases, there are divorce issues, there are child custody issues. We have cases where one family member is trying to get another family member's get control of their money. I mean, there are any number of situations where we have seen this process abused.
Got it. What about in domestic violence situations?
Yes. I mean, I can recall a horrible case I had where a husband had been keeping his wife hostage in the house, and she escaped. And she went screaming down the street, and when he realized she escaped, he called the police, said his wife was crazy, she had serious mental illness, that she self-harmed, she was, running through the neighborhood, he thought she was going to harm neighbors. When the police showed up, my client thought they were there to help her, and she was shocked when the police threw her to the ground, handcuffed her, and dragged her away in the police car. And when she got to the hospital and she was finally examined by a physician, the physician, indicated that she could not have caused all of the damage, all of the harm and injuries to herself that they saw when she was brought into the hospital, and that her husband had been violently abusing her, and we were able to get her out and get her into a battered wives shelter. But the police, they believed the husband when he called because he said she had a mental illness, and they didn't believe her. And so that's happened on many occasions.
Do police have their own independent EP authority that could be used if the police find that a person found a person after a court order is expired, but the officer was still concerned, for example, about that individual's mental health?
Oh, absolutely. I mean, if the order expired and they saw the person, 2 days later, 3 days later, 10 days later, they can issue an EP on the spot if the individual still meets criteria.
Got it. And then last question for this group. I understand that I think from looking at this testimony, that there's a work group that was convened on emergency petitions last year. Did you participate in that work group, or did anyone participate in that work group?
So there was a meeting after the House bill hearing, but there was no formal work group. And I think, I'm trying to remember who was there, and I can't remember off the top of my head. It might have been DRM on her own and a representative from the Office of the Public Defender. And we raised concerns about the bill being unconstitutional last year because as initially proposed, it was unconstitutional. But we were very clear that this is not something that we could support. It was just a single meeting that we were called into, not any sort of ongoing work group about the process.
Okay, thank you.
Thank you, Senator.
Thank you.
The questions are finished for this panel. We're going to bring back the sponsor panel again if we can so that Senator Lamb can ask a couple questions. Thank you for waiting.
Absolutely.
Thank you, and thank you, Madam Chair. So I'm looking at this bill, though I'm not seeing it reflected on the website. My recollection is that I think this bill was voted down last year in the last legislative session. So can you share what, if any, changes have been made between last year's version and this year's version? Because I'm just trying to scroll through quickly. I'm not finding any.
So this bill passed the Health and Government Operations Committee unanimously, the Judiciary Committee unanimously, and the House floor unanimously. It did not pass this committee. And there were not changes. We made the changes after the conversations with the opponents last year so that we used the necessary and proportional language that they requested. We used the presenting behaviors language that they requested. We took every amendment that they asked us to take except for eliminating emergency petitions. This year, after the bill hearing, I spoke with Ms. Lipscomb and Ms. Bergman and asked them to provide me with the language that they wanted for a study and indicated I would put that language in there. My subcommittee chairperson, Delegate Bagnall, also had conversations about this. We held the bill for 2 subcommittee meetings. Our subcommittees are very open and we continue our work there like we did last year. We never received any language. I've always been open to help them with the data that they're asking for, but some of the data that they're asking for is medically protected data that we cannot disaggregate. We can't give it to them. So we need to figure out how to do it, which is why I offered to put the study language in here to address some of their concerns about emergency petitions. They are fundamentally opposed to emergency petitions, but our law provides for them. We just disagree on whether that should be the case. And while we have them, we need to have the clarity for our law enforcement so that they can be safe. I also want to clarify, when they talk about police officers being able to issue these on the spot, that's not what this bill addresses. This bill addresses what happens when the court issues an order, an ex parte order telling law enforcement to go get this person and take them to the hospital. They've received information from either the family or a hospital or medical provider that there is a problem and that this person is a danger to themselves or others. And so the police officer, or in our case, the sheriff deputies, we don't know what they're walking into. And they dress down when they go. They use all of the de-escalation techniques and training that they've received to make it as peaceful of a process as possible. But when a person has a gun, as they did in the instance where our deputies lost their lives, they don't have a choice in the matter, and seconds are life-saving. And so there cannot be this lack of clarity that is currently in our law. It's not clear. It's not there.
So I guess it sounds like it's in the same posture as how this committee voted it down last year. And I guess, looking at the bill folder of testimony, I don't see any, with the exception of like one police officer, don't see any county police department asking for the use of force language. We don't have this language in law governing service of ERPOs or extreme risk protective orders, peace orders or other protective orders. So why, in your belief, do we need it here when the state's use of force law, I believe, already applies to all legitimate law enforcement objectives such as this one?
In this situation, we're asking the police to take a person to the hospital. And if the person says no, they don't want to go, what are they to do? That's the problem. And the other problem is, in the case of a protective order, they're being ordered to have that person removed from the home. And if the person refuses to go, they are absolutely allowed to use force, because in many of those cases, there's actually been physical violence that's evident. It may or may not be the case in a mental health crisis that you can see physical violence that's been enacted by the person that's being petitioned. But whatever presenting behaviors were provided to the court has led the judge to believe that this person is a threat to themselves or others. And our law enforcement officers don't have the clarity they need. And I don't know if you want to ask our law enforcement officers to further expound upon why they believe it's needed.
I think my point is that we don't see any other counties, law enforcement departments asking for this clarity. I represent Howard County, represent Anne Arundel County, represent Baltimore County. I'm not seeing that there's a lack of clarity in some of these other counties. So, I'm just not understanding why there's a lack of clarity on, there's no lack of clarity on ERPOs and peace orders, but on this specifically, there seems to be. The state's use of force law should apply in all situations.
So I'm glad that you bring that up, and I'm especially with some of the other counties. So Prince George's County, we're unfortunately #1 in the state when it comes to the emergency petitions as far as court orders. In many of the counties that you actually may mention to, the first response is dealing with law enforcement or either some sort of clinical technician. With us, we do have a lot of court-ordered emergency petitions. Your other point, as far as why to have clarifying language, in the emergency petition, we're actually taking that individual into custody, and we're actually placing that person in handcuffs and transporting them to the hospital. In our ERPO, there is no custody. We're not taking that person in. We're actually advising them and serving them with that extreme risk protective order, and we're also asking them to relinquish their weapons. So we're taking those, and the peace and protective orders is pretty much somewhat in the same issue. The problem that we have is in this civil order, when somebody is already, and what we already know could be unstable, it's how you interact. So I'm trying to de-escalate the situation as best as possible, but if it escalates, just to say, and the first thing that would be plastered is that why would the officer or deputy in a civil matter take and have to use such this amount of force? And that's some of the issues that we've come into encounter with, is to make sure, especially when we're dealing with law enforcement reform, we want to make sure that we're on the best footing as possible to serve our citizens. Prince George's County, we also have that 3 model where when you do dial 911, they would ask you, do you need fire, police, or mental health? We do have mental health responders that would actually go out. Many times those mental health responders would actually call us to say, hey, this person is acting this way. We feel unsafe. Could you go in and could you at least make the scene safe so that we could actually engage in that individual?
I mean, I get that Prince George's maybe has a higher volume, but I'm just not seeing this concern come out of these other jurisdictions. So I'm curious, has this Maryland Attorney General conveyed to Prince George's County that there's a lack of clarity here in the use of force law? Or I guess another way to put it is there an AG's letter or an opinion suggesting the current use of force law doesn't apply to emergency petitions?
No, we've not received anything from the AG's office in stating that.
So the Maryland Attorney General has not stated that there's a lack of clarity?
I've not received anything as the Prince George's County Sheriff's Office to say such.
And there's no, to the sponsor, there's no AG's letter or opinion stating there's a lack of clarity on that this needs to be clarified in the statute?
I did not ask the AG. I read the statute, so no.
Okay. All right. Thank you. Thank you, Madam Chair.
Thank you, Senator. Senator Ellis.
Yeah, thank you, Madam Chair. And I too was across the way with 2 bill hearings. I missed her testimony, and it's a very important issue. So putting this in statute, I'm just, the bill we passed a couple years ago, AOT, this is an outpatient treatment. Did that bill have any provisions like this in those legislation? I don't know if you can answer that.
I can answer that, and no, it did not. The assistant outpatient treatment model was designed to be as voluntary as possible. There was no provision on emergency petitions or taking people by force to the hospital. We were trying to encourage them to go through the process and get treatment using the, as we call it, the black robe effect of having a judge help monitor their treatment with their treatment team.
So will this bill affect that particular intent, do you think?
I don't think it will have any effect on that unless the person is being emergency petitioned. This only applies when a person is being emergency petitioned through the court process to go to the hospital to receive an emergency evaluation to see if they are a threat to themselves or others.
Okay. But AOT does that too, the assisted outpatient treatment.
AOT is for people who have persistent chronic mental health illnesses that have not been appropriately managed or treated with either their treatment regimen or their medication. This bill, the person may just be having a one-time episode. It may not be a persistent illness.
Yeah. My concern is the analysis won't happen in the field, you know, whether it's one time or persistent, whether this person, you know, have a series of traumatic events in their lives or one time, or I'm just kind of really concerned about taking the civil process, like the sheriff talked about, the civil and the escalation, because if a peace officer I guess that's the term in the bill. I'm concerned with, what is a peace officer? Is that a specific definition to a peace officer, or?
Law enforcement in itself, yes, peace
So that could
officer,
be any
yes.
sheriff or?
Sheriff or police,
or-
yes.
Okay.
Any municipal police
Municipal,
officer,
okay.
yes.
Yeah, go to pick someone up. You're saying they could react anyway without this authorization to respond to someone who's dangerous. So if you go on any issue, whether it's a criminal issue or civil issue, and someone pull a gun on a peace officer, you're authorized in law to respond, correct?
That is correct.
Okay.
And I think also just to the point of what the opponents were saying when it comes to law enforcement, we're trying to change that narrative, how we interact with folks, and just saying that, hey, you already have the ability to do it. We wanted to make sure that we actually have coverage. You hear people now are from the opposing bench saying that, hey, anytime you see law enforcement with a handgun or coming in, we just feel that they're always going to take this approach. We want to try to actually start to define some of these roles and how we interact. We do go to CIT training. We do try to make crisis intervention training. We do go to have our deputies to actually work with our mental health professionals. We work with a lot of the nonprofits. We're trying to, again, change that narrative and make sure that we stand on the good ground. Therefore, we don't have to have citizens of the state to feel threatened by law enforcement, and then for individuals to believe that anytime that we're involved in something, that is going to escalate.
Okay, great. Thank you. Thank you, Madam Chair.
Thank you. So Senator Kramer, do you have any questions? Because everybody else has had one. Thank you, Senator.
Feel free to wrap it up.
That ends the hearing for House Bill 468. Thank you.
Thank you.
And the last bill of the day, and Delegate Harrison, thank you for your patience. House Bill 482, Occupational Licensing and Certification Criminal History Predetermination. And you have Jennifer McDonald virtually as part of your panel.
Okay.
Favorable. So thank you, Delegate.
Well, thank you. First, I want to say thank you for accommodating me and putting me at the end. And I will not take a lot of your time. We did have the Speaker Society event of which I'm the president, and so I respectfully asked to be put at the end, so I appreciate you accommodating me. For the record, I'm Delegate Andrea Fletcher Harrison, and I'm here today to introduce to you HB 482. I want to say good afternoon to each and every one of you, as well as, I guess it's the one member from the EEE Committee, EEE, who's here. So thank you so much. Right? Yes. No. I apologize. I apologize for that. This, I won't bother to read my testimony to you, but what I want to tell you is that HB 482 is a bill, it's a predetermination request by individuals who may have had some interaction with law in the past. It's important to me that people have second chances to lower the chances of recidivism and encourage successful reentry into society. This bill creates as I said, a predetermination process that would require licensing agencies, if requested, to provide binding guidance as to whether an individual's criminal record would be prohibited for licensure. So an individual would ask before they would spend the money and the time going through some certification type of classes, if in fact their issue would prevent them from ever getting a license. And it's so that they don't walk down that path only to be turned at the end to find out that their issue would prevent them from getting a license. I want to say that this is the third year that I've attempted to introduce this bill, and I have worked as collaboratively as I possibly can with everyone who had concerns. And I do believe that that I met those concerns with the way that the bill is currently drafted. There was one error that we all missed in this drafting, and that is on page 3, beginning at line 5, where there's bracketed language, and that bracketed language should have ended at line 7, at the end of line 7. So beginning at lines 8 through 13, that language should remain in the bill. And so I would ask if you would consider that as a friendly online amendment right now. The other thing that I wanted to mention is that the committee the ECM committee did put an amendment on the bill that says that the department should use existing resources, and therefore I believe that there should not be a fiscal note if they're using existing resources. However, when I got the fiscal note today, I saw that there was still some level of fiscal impact. So I don't really know what to say about that if the bill says to use existing resources. I also want to mention that there are at least 27 other states, including those immediately surrounding us. That includes DC, Pennsylvania, Delaware, that either have fully or partially implemented some sort of predetermination process. And then finally, I wanted to mention that in working collaboratively, as I thought that I had with those organizations that may have had some concern, we put in the bill that there's nothing in this bill that shall supersede any compacts or any compacts of any of the professions or occupations that was concerned for the nurses, and that there's nothing that would supersede any department that requires an applicant to have a criminal history review. So in other words, if the department requires that, that would still have to occur. So and I had not heard this year from any opponents of the bill, actually, and so I was surprised to see some of the, at least one unfavorable written testimony or a letter of concern. So I would ask your indulgence and to please have a favorable report on HB 482 with the amendment that I mentioned, and that is to include that language that was bracketed on beginning at line 8. So thank you very much. I'll take any questions.
Delegate, did you say you didn't have opposition in the committee hearing?
I had not spoken with anyone prior to no one had expressed concerns prior to the hearing.
But in the House hearing?
In the House hearing, that is correct.
You didn't have any concerns?
There was no one who came to me prior to the hearing. As last year, there were some concerns, and so I attempted to incorporate all of their concerns to alleviate them in the bill.
Because we have unfavorable from Acupuncture Board, Board of Physicians, Out for Justice. I have unfavorable from the various health occupation boards, as well as Board of Physicians and the Board of Pharmacy. And
as I said, none of them came to me beforehand because I have tried to be as collaborative as I can with everyone who has had a concern. And this year, none of them said anything to me before, which is how we came up with the language that nothing in this bill is to supersede any compacts or any other criminal history checks.
So they didn't come to you before the hearing, but they did submit the same testimony to you in your hearing? I'm just trying to figure out if they've been upfront.
They may have, and honestly, I don't remember. They probably had. I may have been a little flustered because I got the fiscal note at 10:40 that morning for a 1 o'clock meeting, and so they may have submitted written testimony, but I never had a conversation.
Okay, thank you for your testimony, Vice Chair? Yeah.
Yeah, sure. Hey, Madam Chair. Thank you. Welcome to Senate Finance Committee.
Thank you so
Delegate
much.
Harrison. You had alluded to some language. I thought, did you say on page 3 or page 2?
Page 3, at least of my copy.
Right, page 3, line 8.
Line, if you, I'm not, so beginning at line 5, where it says this subsection does not apply to conviction of a crime, that,
Yeah, you must not be reading from the reprint.
okay,
But I think I know what you're talking about.
specifically the 7 years or more is what I'm alluding to that should remain.
Right, got it. Okay. Now, does this, in the Alpha Justice testimony, they alluded to some language that they were successful in securing a couple of years ago, eliminating, and they recommended on page 2, which could have been the original bill or this reprint, to eliminate some brackets. Do you know?
That's the same piece.
That's the same thing?
Yes.
So you have adopted their recommendation to strike that language?
Yes.
Got it, okay. Makes a lot of sense. Thank you, Madam Chair. Thank you.
Thank you, Mr. Vice Chair. I don't see any other questions for the delegate. Thank you. We do have a virtual favorable if you want to stay and wait, Delegate. Jennifer McDonald's favorable. And Jennifer, unmute, please, and you can start.
Thank you, Madam Chair. My name is Jennifer McDonald, and I work for a national nonprofit based in Arlington, Virginia, called the Institute for Justice. For more than 30 years, we've worked to protect the right for individuals to earn an honest living, particularly for those who are working in lower income occupations and for people who have involvement with the criminal justice system. I think you're all, very familiar with occupational licensing and some of the barriers that it can put on folks who are just trying to earn an honest living, particularly when they have just re-entered society after, serving their time for a conviction that they may have had. So as we all know, having a job is one of the greatest predictors of not returning to jail or prison. And so we want to make sure that as many people as possible with criminal histories are able to get gainful employment, to have dignity in the work that they do and when they support their families. The problem here in Maryland is that there are so many people who we think are not even applying for occupational licenses because they know they have the criminal history. So there's a very low rate of applications for licenses from Marylanders who have a criminal history. And we believe that's because they are worried that they are not going to be approved because of their criminal past. So they're not even trying to complete the process to get their license. So this will address that problem by allowing folks to go to the board and say, hey, just tell me ahead of time if my history is going to preclude me from getting this license, so that I know that before I spend money in the school or the other training that is required to get the license for that trade. So this really is just, it's all about fairness and making sure that folks are able to know what they're in for and to know whether they're qualified or not qualified to obtain the license that they are searching for. Last thing really quick on the fiscal note, because there are so few people who do apply for these licenses and are denied because of their criminal histories, we don't think the fiscal note is accurate. We're talking about a very low number of people, but it's very important for the people that this does impact. So we would urge your aye vote on HB 482.
Thank you, Jennifer. Senator Motz has a question for you.
Madam Chair, actually, would it be okay to pose a question to the sponsor real quick? Sure. I apologize. I get the record for questions today. I'm sorry. But this bill is just the bill that says if you want to get an occupational license, you can contact the agency, and the agency can tell you before you go through the hoops and hurdles of applying whether you'll be disqualified or not. Is that?
Yes, the licensing board, not the agency, but the licensing board, yes.
Thank you.
Have any other questions? No, I don't see any. Thank you very much, Delegate.
Thank you.
We have two unfavorables, Michael Tran and Christopher Dews in person.
Christopher Dews here, actually representing Out for Justice, should say we are actually not unfavorable. Our concern was already mentioned by the delegate. We were, a lot of advocates contacted me, terrified that those brackets might actually get put in the statute because the delegate has done phenomenal work meeting and doing all the arrangements. So if this bill would have passed, we just wanted to make sure that that piece was taken care of. She has mentioned that. We've put it in our testimony. So we only signed up unfavorable because we were scared that we would not be able to make sure that you all were aware of this. So we're actually favorable for the bill. As long as those brackets are removed, we're good to go. Thank you all for your time.
Thank you, Christopher. Michael Tran.
Good afternoon, Madam Chair, Mr. Vice Chair, and committee members. For the record, Michael Tran with the Maryland Board of Physicians. First, I would just like to thank the delegate for sponsoring the bill. The board is aware of the intent of the bill. However, as written, we are respectfully opposing House Bill 482. You have my written testimony, so I'll keep to the two main concerns. First is the House amendment. The bill, with the House amendment, the bill would have to be implemented with current or existing resources. Although possible, the board has serious concerns that doing this would delay the licensure of all 15 practitioner types that we currently regulate, which could negatively impact the current efforts to bolster the healthcare workforce. If HB 482 passes, existing staff would have to use or reallocate their time and resources to process these predeterminations on top of their licensing core functions and the other mandated non-licensure groups, such as supervised medical graduates, limited X-ray machine operators, and then the federal exempt military applicants. Our second concern, which I believe we share with the other health occupation boards, is that a predetermination process wouldn't necessarily benefit our applicants or potential applicants. For example, last year in 2024, the board processed around 8,000 CHRC or criminal history record checks. Of those 8,000, 162 were positive. And of those 162 applicants, we denied 0. The board thoroughly investigates all CHRC results. We use all available information such as CHRC, the application, other state resources, and then state medical boards and the Federation of State Medical Boards reports. So with all that, we don't really think a determination would affect the outcome of someone getting licensed and really would just slow down our whole entire process. Thank you.
So the 165, they all got a license.
Correct.
Thank you. Do I have any other questions? Turn the light off or on? My vice chair has a question.
Yeah, thank you, Mr. Tran, for your testimony. What would it take to investigate whether or not a person met the pre-qualification? Your testimony was that it would redirect their work. Like, isn't there online resources that one would use and simply scan to check some of this information out?
Thank you for the question, Senator. So for clarification, are you asking pre-qualifications or for the license or for the criminal history records check?
Well, I thought the criminal records check would play a role into the predetermination.
So the predetermination is based, the way we're understanding the bill is the predetermination would be for a positive or potential criminal history that the applicant may have. So we would be really just focusing on that and only that for the predetermination process. That really kind of puts blinders on the boards as we kind of look at a lot of other information that we get with the full application, which does include a criminal history records check. But without that full application, we're really just looking at the criminal history, which could affect the board's decision on determining whether to approve or deny. Because with more information, we can maybe license with conditions of licensure. But without all that information, we might just err on the side of denying an application.
Right. So with the predetermination, there's not a second step by which you would go and do all of the things that you're already doing.
From the way we have read the bill, we don't believe so.
This would exclude your current process, eliminate your current process.
I don't know if it would exclude our current process. It's just, it would exclude the current information we would have to process an application to deem it or to approve it or deny it. This is really just like a very focused screenshot of an applicant, and it's based on the criminal history records besides the rest of their application, whether that be employment, letters of recommendation, education, time.
All right, thank you, Madam Chair.
I don't see any other questions. Thank you, Mr. Tran. So that ends the hearing for today. Tomorrow, we'll have hearings and a voting session. At 1:30 tomorrow, 1:30, get a little extra time. Thank you.